So let us look at the stages of patent prosecution in India. And when we say ordinary application, so this is actually just a domestic application that has been filed with the Indian Patent Office. Okay, so first let us just talk about this one. And as I mentioned previously, that in patents, the first to file is important, not first to invent. Okay, so the filing date of the application, which is called the priority date, okay, that is important. So an ordinary application is filed with Indian Patent Office. This is a complete uh, application. So it has all the patent specifications, the description of the invention and claims, all those things. And then it is kept confidential. The application is kept confidential for 18 months. Okay, so the idea is that you are able to maintain the secrecy of your invention. At the same time, you have filed an application, so you got a priority date. Okay, because uh, that is the date that if somebody comes with the same invention and files after the date you have filed, then based on the first to file, you will get the preference. Okay, but at the same time you are able to maintain the secrecy of the invention for 18 months. Okay, so after 18 months, the application is published, so that is called publication. And at this point it is open for public to view, and they can even oppose your application, so that is called pre-grant opposition. So from the point of publication till the point the patent is granted, uh, there is a process by which, uh, let us say, government or any individual or any company organization, they can oppose your patent application by saying, based on any ground, by saying that it is not novel, it does not have inventive step, or that the prior knowledge, the prior art already has what you have claimed there, so they can oppose it. Okay, uh, so after publication, then within 48 months from the priority date or the date of filing, within 48 months, you have to ask the patent office for examination. So that is RFE, request for examination. So up to this point they were not examining. Your application is there, and they will also get any pre-grant opposition, but they have not examined it. So then there is request for examination, and they will take some time, maybe a month or two, and they will give the first examination report, FER. So you get FER, and then they give you some time, normally 6 months, which can be extended up to 9 months, to respond to FER. So you have to respond to FER, all the objections that have been raised, you respond to them. And those responses may or may not be satisfactory. So there may be a hearing uh, with the controller of patent, and after hearing there may be a rejection or there may be a grant. Okay, so that is the process. So main things are, there is an application, after application there is publication within 18 months, and after publication there is request for examination within 48 months from the date of filing, and then you get the examination report and you respond to that, and after that, if all objections are cleared, you get the patent, otherwise it is rejected. So even after getting the grant of the patent, there can be opposition, that is called post grant opposition. Okay, so there is a process for that also. And then there are some points here, let us go through them quickly. A patent application can be filed with Indian Patent Office either with provisional specification or with complete specification. Okay, so what I discussed just now, the ordinary application, that was an application with complete specification. Okay, but another option is to go with provisional specification. Okay, let us talk about that briefly here. In case the application is filed with provisional specification, then one has to file complete specification within 12 months from the date of filing of the provisional application. Okay, so let us say you came up with an invention, but you are pretty clear about it, but not, let us say, 100% clear about it. You want to work out some more steps of it, but at the same time you want to file it. Okay, to get the priority date, because first to file is important. Okay, so you are not ready for a complete specification of the patent, but you can have a provisional specification, a provisional application. So you still get your priority date, but at the same time you don't have to uh, write the claim section. Okay, claim section is very important, I mentioned previously, because claim section of the patent application is what for which the protection is actually given. In provisional application there is no claim section. Okay, in complete application there is a claim section. uh, so you can go for a provisional application, you can get the date of filing, and then within the 12 months you can have the complete specifications submitted. Okay, so that is the idea. So provisional application is an application which can be filed if the invention is still under experimentation stage. Filing a provisional specification provides the advantage to the inventor since it helps in establishing a priority date of the invention. Okay. Further, the inventor gets 12 months time to fully develop the invention and ascertain its market potential and to file the complete application. Okay, so that is the idea. So one route was an ordinary application with complete specification. Other is you file a provisional application, and then within 12 months of that you have to file the complete application, and then it goes through the same process. Okay. All the patent applications are kept secret up to 18 months from the date of filing or priority date, whichever is earlier, and thereafter they are published. Okay, and there is a database at the patent office website, so you can go through that. And after its publication, public can inspect the documents, and there is also a provision to request for early publication. Okay, so if you don't want to wait for 18 months, you want an early publication, there is a provision for that also. And then within 48 months from the date of filing you have to request for examination. I already mentioned that. And after examination the patent office issues an examination report, which is called FER, first examination report, and thereafter the applicant is required to comply with the requirements within a period of 6 months from the date of FER, which can be extended by 3 months. So within 6 to 9 months you have to respond to all the objections, and in case the application is found to be in order for grant, the patent is granted provided there is no pre-grant opposition. Okay, or those oppositions have been disposed, and a letter and a patent is issued to the applicant. However, in case of pre-grant opposition, the further action is taken after disposition of the pre-grant opposition. Okay, so that is the process, and this is life cycle of a patent application. Actually, this is uh, you can just go through this. I already explained you the process. The flow chart is given in more detail in this figure. Okay. Now, so that was about getting a patent in India. You can go with a provisional application and then a full application, or you can go directly with a complete application. Okay. Now, what about getting patent in many countries? Okay. So if you want to get patent in many countries, then because patents are territorial, okay, so there has to be a way to enter various countries. So one option is to file a national patent application with each relevant national patent office. Okay, so if you want a patent in India, then file an application with Indian Patent Office. If you want a patent in US, then also then also submit an application in US Patent Office, in Australia Patent Office. So like that, you'll have to submit. Okay. Now, if you want to do that, then there is something called Paris Convention, which is helpful. And the idea of Paris Convention is that actually this convention is very old. I think 1883. So many countries, probably more than 150 countries, signed on this convention, and they agree to certain protocol. They honor certain protocol for in regard to intellectual property. And the idea of the Paris Convention is, let us say you file a patent application in India on say 1st January 2022. Okay, 1st January 2022 you file in India. Okay, and so you get a priority date of 1st January 2022 for India, and now you decide after some time that you also want to file in US. Okay, and say in US you are filing an application in, let us say, August 2022. Okay, but based on this Paris Convention, even for your application in US, the priority date will be considered 1st January. Okay, the date on which you filed the application in India. Okay, so the idea is that under this Paris Convention, you can file an application in one of the countries, okay, who are party to this convention. You file an application on a particular date, then under Paris Convention, within 1 year, you can file an application in any of the other countries which are signatory to this Paris Convention, and still your priority date in all those countries will be the date of filing in the first country. Okay, I hope you get the idea, because filing date is very, very important here. So even though you are filing, let us say 8 months later in United States, say 10 months later in Australia, but your priority date even in those countries will be considered the priority date of filing, actually your first filing in whichever Paris Convention country you did the first filing. Okay, so it helps. So you get that 1 year time period. Okay, if you exceed that time period, then it does not apply. Then you won't get that priority date benefit. So that is one way for getting patent in many countries. Or in certain regions, you can obtain a regional patent from a regional patent office, which is valid in some or all of its member states. So there are regional patent offices. If you get a patent from them, then it won't be valid in just one country, but in a bunch of countries. Okay, depending on that particular regional patent office. And another way is to file an international application under the Patent Cooperation Treaty. Okay, that is called PCT, which is administered by WIPO, World Intellectual Property Organization. So I'll record another session in which we will talk about this PCT. Now going back to the flowchart I showed you previously. Okay, there was an ordinary application and a provisional application. We already talked about that. And this one is a convention application. So that is based on Paris Convention. So, and here it says within 12 months from priority date. Okay, so you file an application in any of the countries which are signatory to Paris Convention, and within 12 months of that, okay, you can file an application in any other country which is also a signatory to Paris Convention, but you will get the benefit of the priority date of your first filing. Okay, so that is this based on Paris Convention. And other is this PCT application. So we'll talk about this in another session.